You may be seated. All right, we've had our panel change, and joining us is Judge Groshans from Orange County. And we are here for the second case, which is Robert DUMIGAN versus Holmes Regional Medical Center. And I'm assuming 5 minutes for rebuttal for the appellant, unless you tell me differently. And you may begin when you're ready.
Good morning, Your Honors. My name is Stephen Biggie. I'm the attorney for Robert DUMIGAN. I would like 5 minutes for rebuttal.
Okay.
This case is about contaminated heparin. Mr. DUMIGAN went in for a routine cardiac bypass in 2008 at Holmes Regional Medical Center. And after the surgery, he developed thrombosis, which is a blood clot. He had multiple blood clots in his lower extremities, and he ended up having an amputation of his left leg and amputations on his right foot and his toes. The issue in this case is we were dismissed on summary judgment, and we believe that dismissal was error by the trial court for 3 reasons. The trial court did not properly consider the opinion of our expert, Dr. Levin. That's the first issue. The second issue is that the trial court improperly weighed facts and inferences in favor of the defendant, who was the moving party during summary judgment. And the third issue is that the court did not enter a ruling or consider our request during summary judgment for a Valson presumption. The opinion of Dr. Levin was based on his review of the medical records.
Your third issue, the Valson doctrine, did you cite to the Valson case or the Valson doctrine below?
When we were requesting the presumption, we didn't directly call it the Valson presumption. We cited the case Golden Yachts, which is a spoliation case, which the plaintiff in that case asked for spoliation inferences and a presumption because of misplaced evidence or lost or destroyed evidence. And we had asked for that presumption and said that the case should not be dismissed because the defendant did not properly record a lot number on the heparin that it gave the plaintiff and did not properly notify him that he may have been administered contaminated heparin during his surgery.
And did that case cite to the Valson case?
That case cited to the Walmart case, which was the case the Supreme Court narrowed down spoliation inferences, where it said you don't have to plead spoliation count. And it talked about rebuttable presumptions when evidence is destroyed or lacking. And that case in itself cites Valson. So we didn't cite Valson directly, we cited its progeny, asking for the same type of relief that was granted in Valson, Your Honor.
Okay.
Dr. Levin's opinion was based on his review of the medical records, and it was based on the fact that the defendant was using contaminated heparin around the time of the plaintiff's surgery. The defendant argued that this was impermissible inference stacking, but the case law states that an opinion from an expert based on circumstantial evidence is not impermissible inference stacking. So we believe that the trial court, when it excluded our expert's opinion or disregarded our expert's opinion, he improperly interpreted and applied that Arkin case to our case. What the defendant needs to show in order to, or basically what the defendant needs to show is that the opinion, in order to exclude the opinion of Dr. Levin, is that it was premised on a demonstratively false assumption of fact. And all the cases that the defendant cites when he argues that the opinion was properly excluded, either the facts that the expert relied on are not included in the record at all. We're talking about the Schindler case, the D'Avila case. We're talking about the Arkin case, that the facts that the experts relied on to reach a conclusion in those cases were not in the record. In our case, there are multiple facts in the record to support that conclusion. And what the case law states is that when a medical expert reviews medical records and gives an opinion on medical records, that's direct evidence. And then so there's no false assumption of fact by Dr. Levin when he's reviewing medical records and giving an opinion based on the medical records that he reviews.
So the facts that you're relying on that are in the record, does that include the fact that maybe all the heparin had not been removed at the time of the incident, the fact that the blood pressure dropped, which is a sign, his maybe not having the same reaction later to heparin? I know that's disputed, but are those the facts that you are saying are admissible, that the doctor made that opinion?
That's correct. And what the defendant would need to show, or what the court would need to see in order to exclude that opinion, is that that opinion is based on demonstrably false assumptions of fact. But those facts are included in the record. They're disputed by the defendant, either because they have conflicting records or because their employees have different recollections of what the records actually state. When you look at the main argument, whether or not there was contaminated heparin on site, there's no way for the defendant to show that that's a demonstrably false assumption of fact.
The main argument is whether or not your client got the contaminated heparin.
That's correct.
Okay, not whether it was on site. And wasn't there evidence that there's a 1 to 5% that your client or someone similarly situated to your client would have received this hit without receiving contaminated heparin? Is that correct?
That is correct, Your Honor. It's a low percentage. When you look at the different laws that apply to situations like this where there's inadequate medical records being kept, when you look at res ipsa, when our client is unconscious and unable to, see what's going on, see what's administered to them, they look at the language is what does it happen ordinarily in the course where there's no negligence, and I would say in a 1 to 5% chance that's not ordinarily occurring outside of negligence. It's a small percentage.
But doesn't that percentage eliminate you from being or prohibit you from being able to use the doctrine of res ipsa?
I don't believe so, because it doesn't say that it doesn't say that it would never occur outside of negligence. It just says ordinarily not occur. And a 1 to 5, if we're looking at the facts in favorable multi to the plaintiff, if we're looking at 1% chance, that's something that does not ordinarily occur outside of negligence. And when we get wrapped up in this particular issue, Dr. Levin also talks about how the onset was rapid. Within 10 minutes, there was clues as to that there was contamination present. And then you look at that other evidence that he received heparin 2 years later and did not have that same allergic reaction. When you look at the record or the doctor's opinion, there's a difference between that 1 to 5% and an allergic reaction. They appear differently. There's a more rapid onset, and he makes that distinction between, there's that ordinary hit, and then there's an allergic type hit, and this one looks like allergic hit, but he doesn't have the allergy because he was administered heparin 2 years later and did not have the allergic reaction. So he makes that distinction in his opinion that way. But even if we get to that issue, well, that evidence is insufficient, even if the court considers this, or reaches that determination that evidence is insufficient to determine whether or not he received contaminated heparin. And, we get to the Valsin issue, but I wanted to reiterate a rule because there was the waiver argument made by the defendant. The case is anesthesiology care consultants, and they make a point in that case that you have to at least try to make a prima facie case before you can ask for those presumptions. And what happened in this case is at summary judgment, the trial court said, well, we see circumstantial evidence, but we don't see direct evidence, so we're going to enter summary judgment. So we didn't even have the opportunity, because the judge didn't even consider it. He just entered summary judgment without he makes a determination that we didn't make prima facie, and then doesn't even consider the Valson argument, the three element issues for Valson, whether the information is critical, whether there's a duty to preserve, and the third is whether it existed at one point or another. So even if we're in that position where this court makes a determination that we need to know the exact bottle, the exact lot number, we still get into that Valson presumption issue that wasn't ruled on, wasn't decided by the trial court. Because when you go through these recalls, you're supposed to recall the lot numbers. You're supposed to be on top of it. You're supposed to know the signs of whether it's being administered. You're supposed to notify the patient when they have a possible reaction. You're supposed to counsel the doctors and let them know. We had Mr. Lyles, who was the perfusionist, who was recording. He had a duty to record. He was recording all the lot numbers for every heparin dose that he was giving. So he was clearly instructed. He clearly had a duty, but that duty was not communicated by the hospital to Dr. Abad, the anesthesiologist. So there's a duty to preserve demonstrated there, which was not communicated to Dr. Abad by the hospital, and it was not being done by Dr. Abad. He just didn't record it. If he had recorded the lot number back then, this case would be open and shut. You'd know one way or the other whether he was administered contaminated heparin. And he did have a duty. And the perfusionist was doing the same thing. He was instructed. Because that duty was breached, we're trying to establish the prima facie the other way by looking at the type of reaction, what happened to him, in his medical records. We have to kind of rebuild it that way. The final issue, I guess we kind of went out of order, but the final issue regarding the facts not being properly weighed by the trial court. The trial court had mentioned that there was only circumstantial evidence, but that was incorrect, because when a doctor reviews a medical record and gives an opinion under the case law, that's direct evidence. So they made improper evidentiary determinations at that point. I believe they improperly credited the testimony of the defendant's witnesses regarding Dr. Abad and Ms. Walling. And the final issue is the court sua sponte determined that his injury was directly caused by peripheral vascular disease, but there was nowhere in the record stated that his injury was caused by peripheral vascular disease. Dr. Levin testified that it may have contributed, but it was not the sole primary cause. So that's another issue that the court was improperly weighing evidence when it made its determination. If you don't have any further questions, I'll reserve the rest of my time.
Okay.
May it please the court. Andy Bolin on behalf of Holmes Regional Medical Center. In the 50-plus years of time that has passed from the time of the La Barbera decision, which is what the appellant relies upon to suggest that circumstantial evidence is sufficient to maintain a negligence case, the courts have all consistently ruled that there has to be some factual underpinning to the opinion in order to draw inferences from. And when we look at this case, the underlying facts of the case are never proven. So specifically, whether or not Mr. DUMIGAN ever actually received contaminated heparin.
Well, the reason that it cannot be proven is because your client never recorded the lot numbers of the heparin that were ever physically in your hospital. Is that correct?
Yes, that is correct, but
So it's convenient to argue that position when your client holds the key to that evidence coming in or that evidence even existing. Is that correct?
Well, the recall that was done by the pharmacy in accordance with how the pharmaceutical companies wanted the recall to be done.
And the recall was done according to lot numbers, is that correct?
The recall was done according to any heparin that was received from the manufacturer, in this case Baxter, that was alleged to have been contaminated.
Which was organized by lot number.
The hospital does receive it and have lot numbers, but they, instead of recording specific lot numbers that they recalled and sent back to the manufacturer, they sent all of the product that they had back to the manufacturer.
But wasn't there evidence that it had not all been sent back prior to the surgery?
There was not. What the appellant argues is that the hospital witnesses were asked whether or not they recorded whether any heparin was taken out of what's called heart boxes, which are boxes that are prepared by the pharmacy, whether or not they went to each individual anesthesiologist, for example, and said, give me back your heparin. And they said, no, they had not done those things. So the appellant draws from that inference that perhaps maybe some of the heparin that was given to those folks or those individuals somehow still exists. There's no evidence that it actually did. We weren't able to talk to any single witness. There wasn't anybody who came forward and gave any deposition testimony or provided any evidence to suggest that they had left the hospital, for example, with potentially contaminated heparin, brought it back in their pocket, and then used it during a subsequent procedure. The only evidence is that the heparin that was used during procedures was coming from the pharmacy. And at the time of Mr. DUMIGAN's procedure, all of the contaminated heparin recall had been completed. This was not something that took place in the midst of the recall. The recall was over, and we were moving forward with heparin that had been sourced from a different company. So the suggestion that perhaps there was heparin still in the hospital is entirely made up of the outcome of this case to suggest that because Mr. DUMIGAN had a complication, then that somehow proves there should have been or there must have been contaminated heparin that remained in the hospital. So they start with the final conclusion and work backwards to support that premise. There is no direct evidence whatsoever that there was contaminated heparin still in the hospital whatsoever. The only two pieces of evidence that their expert, Dr. Levin, is able to point to is, as was already noted, the blood pressure drop that took place during the cardiac procedure. However, the people that were involved in that procedure gave an explanation as to why that blood pressure drop occurs. The perfusionist, Brooks Lyles, says that they would have done that when the patient went on bypass. Dr. Abad, who is not an employee of the hospital, but an anesthesiologist that was working during that procedure, said that it was an intentional drop in blood pressure because had they not dropped the blood pressure during that portion of the procedure, then when they cannulate the aorta, it would have ripped the aorta in half and killed the patient.
But
Now,
isn't that essentially still, though, a factual dispute in terms of if everyone agrees that Dr. Abad adjusted it because of the procedure, but then Dr. Levin says, but it was the result of it, how he reacted to it so rapidly demonstrates that it was different facts. How is that not something that can be, how is that resolved on summary judgment? That's, to me, a straight factual dispute based upon an opinion by Dr. Levin, which the trial bench just basically threw out, versus Dr. Abad.
Sure. So if we were arguing that contaminated heparin had in fact been utilized and that was the cause of the drop in blood pressure, I would agree with you. What we're arguing and what Dr. Levin is arguing is that because there was a drop in blood pressure, it must mean that that coincided with the administration of heparin. There is no causal link between those two things, and Dr. Levin doesn't know whether that's the case or not. He just knows that during the procedure, there was a drop in blood pressure. And to be fair to Dr. Levin, he was never provided the deposition testimony of Dr. Abad, so he wouldn't have known that. And Dr. Levin is a hematologist. He is not a cardiologist. He's not a cardiac surgeon, so he has never even participated in the type of procedure that Mr. DUMIGAN had, and had to admit he wouldn't know whether or not there were things that were taking place during that time or not to intentionally drop the blood pressure. It wasn't, they did not use the heparin to drop the blood pressure.
So the fact that Dr. Levin concludes that this patient reacted in a way that would be consistent with it being contaminated, you just feel that he can't draw that conclusion based upon what he had in front of him?
I think that the case law suggests that in order to draw that conclusion, because and even the appellate admits that's circumstantial evidence,
right,
there has to be some basis from which to draw that inference from. And in this case, that basis does not exist. They cannot, again, if we were able to say that there was contaminated heparin used in this procedure, and we were arguing over the causal effects of what took place afterwards, then you may be able to draw that inference. But in this case, there's no evidence that this patient received contaminated heparin. And so we're using a circumstantial piece of evidence to prove the fact that he must have received contaminated heparin when there is no basis from which to draw that conclusion. And that's the circular nature of this, is that we start with the fact that Mr. DUMIGAN had heparin-induced thrombocytopenia, which is a well-known complication of using heparin even in its non-contaminated format. And there was a question earlier about whether or not Mr. DUMIGAN had the antigen or the antibody that made him susceptible to that. And at 428 in the record, line 5 through 12, Dr. Levin admitted unequivocally that Mr. DUMIGAN did in fact have this antigen. So patients who have that are susceptible to developing heparin-induced thrombocytopenia when they are administered heparin that is uncontaminated. And so we know that Mr. DUMIGAN had this susceptibility. So the fact that he was given heparin and had this reaction is not particularly surprising given the fact that he's one of the types of patients who can have this reaction. So the underpinnings of Dr. Levin's opinion is that it must be that he got contaminated heparin because we know he ultimately had this poor outcome. Well, there's nothing, if you work your way back through the record, to suggest that's true, and certainly nothing that shows that that basis can be shown to the exclusion of other reasonable inferences, which is what the La Barbera court says the foundation of the pyramid has to exhibit. In this case, Dr. Levin himself admits he really doesn't know how that procedure goes, and because he's never done it and he's not board certified to perform it. And there are other pieces of direct evidence, the only evidence in the case, that suggests exactly why those pieces of circumstantial evidence are not consistent with the administration of heparin in any regard, let alone contaminated heparin. So I do want to reiterate the point I think that was made earlier regarding this suggestion of res ipsa being something that the court should consider. The appellant says 3%, his own expert says 5% of the people are going to have a reaction to heparin that is consistent with what Mr. DUMIGAN experienced, even when it's not contaminated. That in and of itself shows that it can happen in the absence of negligence, that it does happen in the absence of negligence, and therefore res ipsa would not be appropriate. This suggestion of a Valsin instruction was never raised with the trial court at any point prior to the day we walked into the summary judgment. There was never a motion to have a Valsin presumption considered. There was never any fleshing out of the argument that the evidence or that the information had been subject to spoliation. There was never any suggestion that there was a request or an affirmative action by the hospital to either intentionally or negligently destroy evidence that would have helped the appellate's case. And it's important to remember that this case has gone on for over a decade and went through 3 different law firms. The trial court allowed 2 summary judgment hearings, the second of which was to come back specifically on the issue of whether or not Dr. Levin could point to something that could conclusively show or at least raise an issue of fact as to whether or not he actually received contaminated heparin, not what the effects of contaminated heparin might be. And that's what Dr. Levin ultimately testified to, that here's what contaminated heparin might look like, and this patient also had a drop in blood pressure. Well, that's okay, except for the fact that there is a conclusively established fact as to why the blood pressure dropped during that time. The medical providers said not, we expect it might have occurred at the same time, or that maybe there is some causal relation. They say definitively, we dropped the blood pressure at this moment to this level in order for the patient's safety so that the procedure could be correctly performed. Dr. Levin admits he can't refute that and doesn't know one way or the other whether or not that was something that needed to be done. And finally, I'll just end with the idea that we cannot look at the ultimate outcome of a case, the fact that there was an injury, and use that to infer or imply negligence. That's well settled in Florida law. So for the appellant to suggest that because there was a complication, then that is sufficient evidence to go before the jury, I think is inconsistent with the way that the law ascribes the burden of proof. Thank you.
Thank you.
Your Honors, there's a disputed issue of fact with the way that the appellee's counsel is characterizing Dr. Levin's testimony. Dr. Levin's testimony regarding the drop in blood pressure was based on the drugs that were administered to Mr. DUMIGAN, the blood pressure would not have dropped the way it looks in the chart. The argument that opposing counsel is taking, that Dr. Levin somehow admitted that he was wrong, or admitted that the blood pressure was related to something, the drop in blood pressure was related to something else, is totally incorrect. His testimony was very clear that the drop in blood pressure would not behave or drop that way based on the medication that was given to him by the anesthesiologist. It was very clear in that testimony. The issue regarding circumstantial evidence not being sufficient is incorrect. The defendant criticizes our use of the La Barbera case, saying that it's too old. The Arkin case that he's relying on is even older than that one. The La Barbera case specifically states that an expert's opinion can be based on circumstantial evidence. And their courts have consistently stated, the cases we cited in our brief, the Nielsen case, the Bunyak case, that negligence cases can be built on circumstantial evidence. There's no case law out there that says that a negligence case cannot be, or negligence plaintiffs are prohibited from building cases on some circumstantial evidence. That's not the law. It'd be impossible to prove a case of negligence if you were not allowed to rely on circumstantial evidence, because it's something that's used constantly for accident reconstruction, for food poisoning cases. All that requires circumstantial evidence. It all requires experts to go back and look at what did occur to formulate an opinion as to causation. The circumstantial evidence regarding the heparin still being on site, there's multiple pieces of evidence that are undisputed or not disputed by the defendant. The fact that Mr. Lyles was still looking for contaminated heparin on the day of the surgery, that's not disputed. The fact that our expert, Mr. Hawkins, our hospital administrative expert, was asked in his deposition, opposing counsel stated that the recall was completed by the time Mr. DUMIGAN went in for surgery. Our hospital administrative expert, Mr. Hawkins, was asked directly, well, wasn't the recall completed by the time the surgery was completed? And our expert said, no, it was not completed. You cannot complete the recall until you can attribute that all the contaminated heparin was removed from the hospital. And there are no facts to suggest that all the contaminated heparin was removed from the hospital. Even when Jill Walling, the employee in charge of the recall, was directly asked, do you know if all the contaminated heparin was removed from the hospital, her answer was, I don't know, we don't know. There's no way we can establish that. So for the appellee to sit here and argue but number one, it's a factual dispute, but number two, it's totally incorrect, that they had removed all the heparin from the hospital and that the recall was completed by the time Mr. DUMIGAN went in for his surgery. Number one, it's disputed, and number two, there's no facts that back that up. The facts show that it was there, that it wasn't all returned. They were still looking for heparin when Mr. DUMIGAN was in for surgery, and they had no idea whether they got it all or not. Dr. Levin's opinion, he testified in his deposition within a reasonable degree of medical certainty, more likely than not, that Mr. DUMIGAN was administered contaminated heparin. That was his opinion. The defense, or the appellee, argues that he somehow conceded that opinion or didn't give that opinion. It's in the transcript, black and white. What is his opinion? His opinion is within a reasonable degree of medical certainty. It is more likely than not Mr. DUMIGAN was administered contaminated heparin. It's an issue of fact. All we've talked about, or all the appellee has been arguing, has been facts, just disputed facts between the parties. It's an issue that has to be resolved by a jury. Thank you.
And we're in recess.